Welcome to another gripping courtroom breakdown. In this case, we have Daniel McCoo standing before the judge with multiple felony charges, including fleeing and eluding police, operating an unregistered vehicle, and, perhaps most shockingly, escape from lawful custody. This case has twists, turns, and tense moments you won't want to miss. Stay tuned as we break down every detail. Was this just a series of unfortunate events, or is there more to the story than meets the eye? Right from the start, you can sense the tension in the air. The defendant, Daniel McCoo, is already on the defensive, seemingly anticipating a storm of trouble ahead. But here's the question: why does he look so sure that this will somehow all fall on his shoulders? The atmosphere is thick with uncertainty. Is he playing the victim, or is he genuinely overwhelmed by the charges against him?
Am I? In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That were going to be addressed. That would be addressed at the...
Here's a pivotal moment in this case. McCoo challenges the charges based on the definition of imprisonment. His argument? The facility wasn't a jail, but a hospital. Is that enough to get the charge dismissed? The law clearly states that imprisonment needs to be in a governmental facility, but does the hospital status really change the outcome here? This could be the start of a legal loophole that might favor the defendant.
Our Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all 3.
Sir, do you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am.
McCoo is now looking for a preliminary examination, but the judge isn't letting him off easy. He's asking for all charges to be dismissed on an oral motion, which is a bold move, but one that's likely going to be shot down. A motion like this requires more than just words. It needs evidence. And from what we're seeing, it's clear the prosecutor isn't about to back down that easily. But is McCoo just trying to buy time?
He has let me know that all paper discovery has been sent to Mr. McCoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McCoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten a
He
video.
has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McGoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that that's not the case and the officer.
Now, McCoo has invoked his right to a speedy trial. This is a crucial step, but the timing is telling. He's facing serious charges, and the lack of evidence, like missing video footage, could severely damage his defense. Is this a strategic move, or is McCoo genuinely trying to speed up the legal process? This is a risky move, and we can't help but wonder if it's going to backfire.
And I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. McGoo, starting in case ending in 0979. Mr. McGoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration of $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025. I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively. And 60 to 180 days community service, any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution plus the cost of any emergency government.
Here's the twist. The judge brings up the fact that McCoo is requesting to represent himself in court. This is always a risky decision. While it's his right, self-representation often ends in disaster. McCoo is warned of the perils, but he's undeterred. Is he overestimating his legal knowledge, or does he genuinely believe he can win this case without a lawyer?
$1,000 fine plus court costs. Mr. McGoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. McGoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance.
McCoo's request for a public defender is finally granted. It's a smart move, especially given the complex charges he's facing. The court emphasizes the seriousness of self-representation. If he had proceeded alone, it could have led to disastrous results. Now he has a professional by his side. But here's the catch. Will the public defender have enough time to catch up with the rapidly unfolding case?
But I will set these for preliminary examination.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
And a response from the people regarding his bond.
The people would ask the bond to continue, and he also, I'm sure, failed to appear before the judge's plate. So
Yes.
that warrant would also hold up with respect to the other. I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment in Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the Public Defender's Office.
Yes.
Now, McCoo's legal team is claiming due process violations. They argue that the prosecutor's delay in bringing charges constitutes a Sixth Amendment violation. McCoo's defense is pushing hard for dismissal based on this, but let's not forget, delays in court are common, and the outcome here isn't as clear-cut as they would like it to be.
Judge Slay's case.
That's my understanding.
The bond has been denied, so
That's what I heard.
what I would
Mr. Trudeau said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence.
The judge refuses to change the bond conditions, citing the severity of the charges and McCoo's potential risk to the public. The defendant's escape charge looms large, but what does this mean for McCoo? It's clear the judge is viewing him as a flight risk. Could this decision be a strategic move to ensure he doesn't attempt to escape custody again?
Charges
You know
just
what?
like the fleeing and
evidence
eluding
will
charge.
not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter.
As we approach the conclusion of today's proceedings, we see Macau pressing for what seems like an act of defiance. He's filing a civil claim against the judge and others involved. This move is bold, but is it a calculated step to shake the foundation of this case, or just an attempt to throw the court off track? It's a move that could backfire. Attacking the system rarely helps a defendant.
One of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people, individuals, without specific reference.
Now, McHugh's accusations against the judge take a dramatic turn. He claims impartiality is compromised due to a personal conflict. This is a huge accusation, and if there's any merit to it, it could lead to a change of venue. But as the judge firmly denies this request, the question remains, will this case continue under the same jurisdiction, or will McHugh find a way to shift the tides in his favor?
The prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here.
To wrap up, McHugh is facing multiple charges, with some serious legal maneuvering on both sides. The case is set to continue, with the preliminary examination looming large. Will the charges stick, or will McHugh's defenses find a way to tear them apart? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.